Welcome everyone. Today is Thursday, and this is our first Thursday presentation. And today we're going to be talking about embracing asset protection as a core component of your practice. I'm happy to have you all on. I see there's many people logging on, and we'll continue to do so. So we're just going to jump right into it. My name is Douglas Lodmell, and I'm the co-founder and managing partner of Lodmell & Lodmell PC. We're one of the nation's leading asset protection law firms. We've been doing nothing but asset protection since 1997. And we are also the creators of the Bridge Trust, which we're going to talk about today, which is really a revolutionary concept that has combined really the strengths of all the asset protection options available. I'm also the founder of the Asset Protection Council. And the Asset Protection Council is designed to support attorneys in adding asset protection to their existing practice. One thing I've learned over the last 20 years is that smart attorneys look for expertise outside of their area. And as clients are asking for expanded services, particularly asset protection, you want to be able to deliver that. The Asset Protection Council is exactly designed for just that, to help you deliver asset protection at the highest level to your clients. So let's talk about it. Asset protection. Clients understand that litigation is a fact of being in business in the United States. They're asking for it. They want to be informed. I can tell you this is true. I do nothing but sit on the phone all day long with clients for the past 20 years, and I can tell you they want it. They are asking for it. And my feeling is that they should be getting that from you. Most of you on this call are primary attorneys for your clients in one form or another. You're their estate planning counsel, you're their business counsel, or you're just their general counsel. One way or another, if you're not able to help them understand the asset protection options, they're going to go to somebody else. And often they just call me. They get online, they Google, they find me, and they call me. I'd much rather them find you and work through you. So why does asset protection work? Well, it works because we create a wall around the client's assets that basically discourage a plaintiff's attorney from seeing our clients as any kind of easy target. And this encourages either dropping the suit altogether, I mean, people just walk away from weak lawsuits, or if there's any merit to it, it encourages reasonable settlement that are really on the terms of our clients, not on the terms of the plaintiffs. And asset protection really does work. I know, it's a question mark for a lot of you. Well, does this really work? I can tell you firsthand, with thousands of cases, it really does work. It's extremely effective, and I know some of you have also seen this firsthand. Believe me, if you take away the prize, if you take away the capacity of a plaintiff's counsel to see the money at the end of the rainbow, their energy to go forward in a lawsuit just diminishes, and that's what we want. However, for it to work, a couple of things have to be true. It's really got to be seen as virtually impenetrable. It cannot be a weak form of asset protection. You've also got to skillfully manage it. And I really can't even overstress this part. It's not about just having it and flopping it on the table. It's about skillfully revealing it, how you reveal it. And it's really, I often tell clients, it's like playing poker. The best poker hand is not usually the hand that wins. In fact, you rarely go to a showdown. The best played hand is the hand that wins. And that may have been the best cards, or it may not have been. And the best players know that they don't need the best cards to win. They just have to play the best. There can't be any obvious vulnerabilities to the structure. Again, this kind of goes with number one. It's really got to be seen as impenetrable. And most importantly, it can't be a bluff. It's really got to work. And unfortunately, there are some asset protection structures that are being promoted out there that are more or less a bluff. And the problem with those is that, one, attorneys are getting smarter and smarter as they are seeing a lot more asset protection structures. They know which ones are really going to work and which ones are not. If they call your bluff, you're holding the bag. I mean, your client's the one that's going to be looking at you going, hey, I thought we did asset protection and it didn't work. So my feeling is it better not be a bluff for your sake and for your clients. So what do clients want? Well, this is really clear. They want it to be effective. And again, it's got to work. They want to control everything. We know that, right? They all want to control everything. Some of them past their death, some of them forever and ever, 5 generations down. They want it to cost reasonable amount of money. And I would say free, but no, my clients don't want it for free. They actually really do respect what it takes to get this done right, but they do want it to be reasonable. They want it to be competitive. And they don't want a lot of burden around it. An extra tax return is one thing, but if you start talking about compliance requirements and IRS disclosures and lots of invasive stuff, they usually are pretty opposed to that. So these are what they want. So let's see what we can give them. Let's see how much of this we can give them. I'm going to talk about 3 tools today. You're going to know 2 of these, which is the limited liability company and the limited partnership. I call it an asset management limited partnership. Of course, family limited partnership is a common name, but it's drafted very specifically for asset protection. And then the third tool is really the key component. This is the part that is new to a lot of people, and this is the part, frankly, that has the most misinformation or confusing directions. And when we're done with this webinar today, you will have a very clear understanding of what an asset protection trust is, what the different forms of it are, and how and why it works, and hopefully understand what the best way to do one is. So quickly, let's just talk about the common tools. Limited liability company, we know what this is for. This is to wrap up risky assets, boats, planes, investment real estate, businesses. We put LLCs around our clients' individual risky assets. It segregates those assets from each other and from the client. And as we know, it has charging order protections. And if any of you have seen charging order protections in action, when they work extremely well. They really do stop a creditor from collecting on assets. So we don't disregard them. We like them. We think they're very good. I don't think they're foolproof because we have too many examples where judges have decided that they're not going to use the charging order. But plenty of them where they do respect the charging order, so we're going to use them. The second tool is the asset management limited partnership. In our model, this is the holding company. This is what goes really, this is where the client is going to accumulate the bulk of their assets. It can hold the LLCs. So if a client has an LLC with some rental property in it, that LLC would in turn be owned by the asset management limited partnership. And in this context, it's okay if that LLC is a single member LLC. Why? Because it's held by a multi-member charging order protection entity. So why would we want a single member versus multi-member at the lower level? Well, imagine a client with 5 LLCs holding different assets. If they're all single member, we're talking about 1 tax return at the asset management limited partnership level versus 6 tax returns. And again, clients value simplicity. They value ease of maintenance a great deal. And from an asset protection standpoint, as long as we're not talking about the client being the single member, we have all of the protection we need. Arizona is a great state for the charging order protection. They continue to just stand behind it, making it the exclusive remedy by statute, and the case law we have there is really strong. So we like Arizona. Another benefit to Arizona is that it does not require an annual maintenance fee to the state, nor does it require even an annual filing. Most states require you to go log on online, fill in a form, pay a $85 to $150 fee, and fill out new paperwork each year. That's just a point of failure in my book. I mean, it's not difficult to do, but managing thousands of partnerships, it would be a major full-time job. Either you pass that on to the client, which you know they're not going to do it every year, or you do it on behalf of your client, and now you've built in an extra cost for yourself. In Arizona, we don't have that. Your partnership is not going to get administratively dissolved because you forgot to do it for 1 or 100 of your partnerships. So it's just a great state from that standpoint. And we also can include the family as a limited partner, just like a traditional family limited partnership, and of course the asset protection trust. And if certain clients do want privacy around those assets, we can accomplish that. we would do that by adding a Wyoming limited liability company as the general partner. And in Arizona, only the general partner needs to be listed to file the partnership. And if that general partner is itself a Wyoming LLC that does not reveal the members, what we end up with is a privacy shield protection entity. And some clients we do that for because they value it, some clients we don't. It depends on the client. So let's talk about the asset protection trust. This is really the key. This is the part that makes it work. This is the part that the clients like. This is the sexy part. This is also the part that has the most moving parts and the most misinformation out there. So I'll tell you the result of it when it's done right, and then we'll dive back into how it works. So when you have the asset protection trust in place, the assets can ultimately be moved. And if we're talking about a foreign trust, moved away from the U.S. court system. It enhances the domestic structure that we just talked about. It enhances the limited partnership and the LLCs by having an exit. It's not limited to any specific risk, obviously. And this is something we explain to clients a lot is, liability insurance focuses on the risk. The risk of driving a car, the risk of your house catching on fire, the risk of somebody slipping and falling in your office. Asset protection doesn't focus on the risk. It focuses on the assets. So it's risk neutral. It doesn't matter what the risk is. And when clients get this, they love it. They love that they don't have to identify a risk, that it's covering the assets. And it's not that we tell them to get rid of their insurance, not at all. It's just that insurance is insufficient. And it really is. I mean, for the most part, insurance will cover some, but definitely not all of the risks that clients take on. And it fails. I've seen too many times clients fighting both the underlying claim and their insurance company for coverage. And I could talk for an hour on insurance companies and the woes of my clients, but I think everyone on this call probably understands that. And again, privacy and protection for your assets. So what is an asset protection trust? Well, in the context of the way it has become known in the asset protection community, it is a self-settled spendthrift trust. That's what an asset protection trust is. There are other trusts that are not self-settled spendthrift trusts that also protect assets, but they're not known as asset protection trusts. So when we're talking about an asset protection trust, we're specifically referring to a trust that is self-settled, just like a revocable living trust is, but that contains spendthrift provisions that limit the settler's access to the trust assets and hence limit a creditor's access to the trust assets. That is the key distinction. There are two schools of thought or two ways to go about this. You can do it internationally, or now you can do it domestically. So let's talk about each. Let's talk international first because this occurred first. It was created in 1984, and we're going to talk specifically about the Cook Islands. And the reason is that they were first. They really opened the door to international asset protection. The Cook Islands Trust Act was created in 1984, and it was written specifically to make it very, very difficult, if not nearly impossible, for someone coming in and challenging a trust to actually break into the trust. So first and foremost is there is statutory requirement that the Cook Islands not recognize any other jurisdiction's court orders or judicial proceedings. Not recognized. So that means that a U.S. court judgment, order, Supreme Court order, doesn't matter. In the Cook Islands, they are statutorily prohibited from recognizing that. You have to start your case over in the Cook Islands. You're going to have to go down there. Oh, and by the way, you're going to have to prove that case beyond a reasonable doubt. So they moved the standard. As we know, that is a very, very difficult burden to meet, beyond a reasonable doubt. And we're just talking about for civil cases here. We're not talking about criminal. There are no contingent fees attorneys allowed in the Cook Islands, so you better bring a big checkbook if you're going to go down there. You're going to have to figure out how you're going to find an attorney first of all, and then you're going to have to pay them. Once you file a claim, it's not amendable. So unlike here where fishing expeditions are common, where you simply file and then you keep amending and get into discovery and figure out what to amend and add, you can't do that there. If you do lose, you're going to pay the fees and costs for the winner. Well, What are your chances of losing if the burden of proof is beyond a reasonable doubt? Very, very high. So now you're looking at a very real financial risk to file a case in the Cook Islands. Statute of limitations there is very short, so the chances of you actually getting down there in time to even start a case are pretty minimal. So those all sound really good. So what are the pros? What's the benefit of an offshore structure, or specifically a Cook Island structure? Well, effectiveness. We now have 30 plus years of history with the Cook Islands since 1984, and we've got a lot of cases that show the effectiveness. I've picked 3 here. These are 3 bad cases. This is kind of the worst it gets for the offshore trusts. FTC versus Affordable Media, which is famously known as the Anderson case, the Grant case, which is much more recent, 2008, and again, Anderson had the FTC as a creditor, Grant had the IRS as a creditor, and Salo case had the SEC as a creditor. So all super creditors, all the worst kind of creditors to have. I'm not going to brief all these cases here. I will tell you that they are all briefed in full on my website at assetprotectioncouncil.com. Go to the resources tab and go to case briefs. But I just listed them here so that you can see that these are all cases that kind of went bad for the person setting up the trust, the settlers, and nevertheless they all still worked. So again, it just shows how strong the International Asset Protection Trust really is. What are the cons? Well, number one is just offshore. Clients really have a challenge getting comfortable with offshore. It's not something that they just naturally say, oh yeah, no problem. Compliance. The IRS reporting, when you have a foreign trust, you fall under 7701 A30E, the foreign trusts distinction, and you have to file Form 3520, 3520A, FBAR, and the FACTA disclosures for any accounts that are offshore. And the costs, the fees and the costs are just higher, as you can imagine, going offshore. And when I say clients have challenges getting comfortable offshore, see that as the control element, because now they're talking about giving up control to a foreign trustee. And what I've learned is that certain clients, the real minority, go, yeah, I understand all that, and I'm going to go for that. But the vast majority just say, wow, this is kind of a game stopper for me. So we've got the best possible protection in the world, but a real hurdle for clients to just get comfortable. And if any of you have done some asset protection in the past or have used offshore trust, and I hear this very commonly, yeah, I did this in the 80s or the 90s when they first kind of came out, and I did 1 or 2, but I could just never really get clients involved and comfortable, and I never got comfortable, so I just didn't do more than 1 or 2 of them. I hear that a lot. And we're gonna talk about the option. So the cons: control, offshore trustee, that's a big con. Compliance, IRS compliance every year, a big con, and the cost. So that's why they're not more popular than they are. So let's talk about the domestic option. Does it solve any of these problems? Well, the domestic self-settled spendthrift trust, the DAPT as it's become known, has gotten some popularity. They're newer. They started in 1998, and that was in Alaska. And very quickly thereafter, we had about a half a dozen states almost immediately jump on, the common suspects, which is Nevada and Wyoming and Delaware. I mean, they just jumped right on. But every year we're getting more. So we just added Michigan this year, which, again, Tennessee and Wyoming and Rhode Island. So we have 17 states, a third of the states that have a domestic asset protection statute in some form or another. They're all very different. Some are pretty good and some are really not so good at all. But it's really showing that the idea is catching on. And what I like about it is that it really shows that it's very hard for, to make a public policy argument that somehow a self-settled spendthrift trust is invalid or against public policy when you've got a third of the U.S. states that specifically have statutes that allow for them. So it's really kind of validated the entire concept of a self-settled spendthrift asset protection trust. And again, they're often paired with an LLC or a limited partnership to provide that charging order protection. And that's also true with the foreign trust. That's almost always the structure that I see is a trust, domestic or foreign, paired with a charging order protection entity, LLCs, LPs, or a combination of both. So what are the pros of the domestic? Well, there's no offshore component. So clients really are more comfortable. And there's minimal IRS reporting requirements. I mean, there's really not any. I mean, you might have a tax return for the trust, but that would be the extent of it. There's definitely no foreign compliance reporting requirements. And they may be less expensive. I say may because the price of these is all over the board. Some of them are just as expensive as the foreign counterpart. Some of them, the maintenance annually is more expensive than the foreign counterpart. So cost is it's not uniform. It's all over the place. But, you know, that means in our 4-part test, compliance is a plus for the domestic trust, and maybe the cost is a plus as well. How about the cons? Well, this is really where rubber meets the road, right? Article 4, Section 1 of the U.S. Constitution, we all know it. We learned it semester 1 in law school. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. So as much as Nevada or Alaska or Delaware would love to say, hey, we're an asset protection trust jurisdiction against California, they can't. I mean, they can't disregard the judgment. And remember, if we look back to the Cook Islands statute, it's just the opposite. Cook Islands is statutorily prohibited from recognizing any other jurisdiction's judicial proceedings. Well, in the United States, every state must give full faith and credit to every other state's judicial proceedings. That means they can't just disregard a judgment from another state. As you'll see, this creates a big problem for the domestic asset protection trust industry. We also have conflicts of law issues. You know, the trust is being heard or the case is being heard in one jurisdiction. Maybe they're not going to apply the law of the trust stated jurisdiction to the trust. And then, of course, we have the federal and the bankruptcy courts that sit on top of the state courts. So the net effect is that on top of that, even within the state statutes, most of the states have a whole list of exceptions that are outside of the protection. Certain tort claims, alimony, child support, divorce, pre-existing claims, fraud claims, criminal activity, tax evasion. Not that we're going to be encouraging our clients to use asset protection for any of these, but it's just more ways in which an attacker can use to get into the trust. So are they effective? Well, I think the case law says they're not. I've listed 4 cases here. These are all domestic cases. And again, I picked the bad ones. You know, Batley versus Morrison, Huber, Stillman, and Dahl versus Dahl. These are bad cases for the domestic asset protection trust. But I just wanted to highlight that a bad case in a domestic trust results in a complete failure of the trust. In other words, all these assets were recovered from the trust, so there was no effect. If you remember in the offshore cases, those were also bad cases that really were decided against the trust, but the net effect was that those trusts all still saved the assets. So that's the difference. A failure in a domestic context means a failure completely and the assets are taken. A failure in the offshore context means that you got a bad result. The court said, yeah, you know, trust fails, but Cook Islands didn't say it failed, so the assets are still sitting safely offshore. And again, you can go on to the Asset Protection Council website. There's full case briefings of all of these cases, so you can read them for yourself. Okay, so cons. Look at our 4-part test. Is it effective? I can't say that they're effective. I don't feel comfortable putting a client in a domestic only, a pure domestic asset protection trust. Control. In a domestic asset protection context, removing the client from the control element is even more critical than in the foreign context. So think about why. Because in the domestic context, you really have to have everything perfect, every I dotted, every T crossed. You've got to get the client out of the control position because you're going to be arguing this in front of a domestic court who's going to be deciding whether the statute fits and whether you fit the statute. And so you actually have to be more restrictive in drafting and using a domestic asset protection trust than you do with a foreign asset protection trust. because in the foreign trust, you're always relying on the offshore court to effectively protect you. In the domestic trust, you better be right on if you're going to expect a U.S. court to even consider extending the protection to you. And again, you're going to find clients hate this. They do not want to be out of control. Let's look at what clients want again. They want it to be effective. They want to keep the control at least as long as possible. They want the cost to be reasonable, and they don't want all that compliance. So what's the option? And I'll tell you how we discovered this, or how I came up with it. 20 years ago, there was no domestic option. There was only the foreign option. And I quickly found out as I entered the practice, and my father was my partner, so I was mentored by him, and he was one of the first attorneys in the country to really actively begin using the Foreign Asset Protection Trust, right back in the beginning, in the 80s. And what I found is that even back then, these four things were still the things that they wanted. And the foreign component was always a challenge. So I asked myself, well, how can we reduce that? And what we came up with all the way back then was called the Bridge Trust. And the Bridge Trust is really combining the offshore protection, but with the simplicity of a domestic trust. So here's how it works. It's a tax-neutral domestic grantor trust. Domestic. Get that. It is a domestic trust. Because it's a domestic trust, there's no IRS Form 3520 or 3528 because it doesn't fall under 7701 as a foreign trust. Therefore, there's also no IRS, FinCEN, or FACTA disclosures because we're not telling the clients or recommending to the clients that they need to set up offshore accounts. There's no IRS filing requirements because it is treated just like a revocable living trust. It's a domestic grantor trust, so it can literally use the client's social security number and basically be an invisible grantor trust. Assets can remain in the U.S. with their current bank, of course, inside of the limited partnership in the LLC, so we still use that structure. Clients love this. It means simple for them. We do not have to have an initial foreign trustee. Why? Because the client can be their own trustee. And this is probably the key component that just makes clients go, oh, okay, got it. And that's the end of the conversation about, what is my control element. This makes it much easier for clients to accept this, which is why we have done so many of them over the past 20 years. We really just have changed the model in what it is to have an asset protection trust with the Bridge Trust. So how does it work? Well, if the trust is ever challenged, the protector declares an event of duress, and the trust is domestic for 7701, but it's also already registered offshore. So it's really holding two passports. It's holding the offshore passport and it's holding a U.S. passport. And just like the Irish, tax arbitrage that Google uses and Apple uses, which is based on how each country sees the domicile of the company, we're doing the same thing here. From an offshore perspective, this is an offshore trust, and we get offshore protection. From an Irish perspective, it's a domestic trust, so we don't have any of the compliance requirements. This makes it effective because if we ever have to use it, it becomes a fully foreign offshore trust as of the initial inception date of the trust. So way back in 2017 when we set this up, it's considered an offshore trust from the offshore jurisdiction. And if we don't trigger it, if we don't have to convert it until 2025, then it stays domestic trust. And only in 2025, when we have a real attack, do we have to drop the domestic U.S. citizenship and remove the client as the trustee. And at that point, foreign trustee becomes the full trustee, and then the assets move. And again, I can tell you from experience, clients are completely fine at the stage where they're really running for their lives trying to protect their assets. All of a sudden, getting comfortable with an offshore bank and an offshore trustee is really not a big hurdle for them at all. It goes from being a game-stopping hurdle when they're setting it up and no one's chasing them to oh, no big deal. I'm totally comfortable. Let's just protect my assets. And so that's why it works so well. Control. Well, client is the trustee. They have the control. So it meets their test for that. Cost. It is right in the middle of the cost zone. It's on the low end from the offshore perspective. The cost for the bridge trust is $23,000. Offshore trusts run anywhere from $20 to $50 to $100,000. So we're right at the bottom of that. I don't get any pushback on cost at all. It's right in the middle. And compliance, there's none. As long as it's domestic, there's no compliance. When it becomes foreign, yes, it'll have all the foreign compliance requirements. It'll have all the foreign costs. It'll all have all the foreign control elements. But remember, at that point, clients are very accepting of it because now we're really using it so they understand it and they're willing to do it. So it's just a great tool. We have thousands of instances of success around this. We've had to trigger the trust many times over the past 20 years, most of those coming in the past 8 years, I would say. Really since 2008, we obviously got a big uptick. We've never had a forced extraction from any of the assets of any of our clients. And again, it's effective. It works when pushed. And for the most part, clients are able to use the structure to negotiate the terms that they're happy to settle with. And when I'm talking to clients, I'm always reminding them that, look, it's not about telling the other side to pound sand most of the time. It's about getting to a place where you can find something reasonable, where it makes it go away for everybody. If you do have to tell the clients to pound sand because they're just not going to listen to anything else, when they pound sand, they really do pound sand. They don't get anything. They don't get anywhere into the trust. So let's put it all together. Asset Management Limited Partnership is in the middle. That's the holding company. That's where we're going to get everybody to consolidate all their assets. The client is going to be consolidating assets inside of the limited partnership. Here we have LLCs. So let's say you're going to put a condo in one of them, a sailboat in another one, an airplane in another one. Whatever risky assets the client has, we're going to use limited liability companies to wrap them up. Then we have the bridge trust, and we still are going to use the revocable living trust. This is still part of the structure. So how does it work? The LLCs go into the Asset Management Limited Partnership, and if everything goes great, if there's no issues, then client eventually is going to pass it to the revocable living trust. What else goes in there? Cash, stocks, collectibles, any kind of financial instrument asset is also going to go into the Asset Management Limited Partnership. Who's in control? The client is the general partner, either directly or indirectly through a Wyoming LLC if they want privacy. Who is the owner of the limited partnership? The bridge trust. Let's call it 98, 99% limited partner. So the bridge trust owns it all, client controls it all. So what happens? Well, client is ultimately going to die. And in that case, the assets are just going to pass through the revocable living trust. And the bridge trust assets also, there should be an arrow really pointing down to that revocable living trust. They're going to all pass through the estate plan. Going to distribute assets for the kids, maximize their exemptions, avoid probate, and smoothly pass the estate. That's the goal. And by the way, kids can keep the bridge trust in place if they're smart and continue to use the protection. The other option is we get sued. And if we get sued, what happens? The assets are going to go to the bridge trust, and if necessary, and believe me, if we're triggering the trust, it's probably necessary, we're going to actually take them offshore, and they physically will move. That means opening a bank account and getting the assets out of the country. And I'll explain one more piece of that, and another reason why we really like Arizona. In Arizona, the statute says that a limited partner can unilaterally withdraw from a limited partnership upon the occurrence of a predefined event. And that's good, because what we want is that trustee, which would become the offshore trust company in the event of duress, would be the one withdrawing from the partnership and basically requiring the general partner to distribute the assets. It's done by statute in Arizona, so it's very clear. And what is the predefined event? The declaration of an event of duress by the protector. That's the predefined event. So it really does work perfectly together to remove the client from the control position. The client's not declaring an event of duress. The client is not making the determination to transfer the assets offshore. The client is just doing what he's required to do. And all this, of course, is going to happen prior to a judge really getting involved. And so here, the delay in the legal system really works for us and our clients. Clients say, oh, legal courts take forever. And I'm like, yeah, that's a good thing. It just gives us miles of runway in order to get everything moved and positioned how we want it. So, okay, let's just go with some questions. I've already got a few, so I'll just jump right in with questions. Type them in if you've got them, and I'll just get through as many as I possibly can. All right, first question, Don, what about bankruptcy, repatriation orders, and contempt? It's a great question. This is probably the one I answer the most when I'm on the phone with the client. It's the one that kind of is the boogeyman of asset protection. You know, the court, we all feel like, oh, the court is just going to tell us, tell our client, if you don't do this, you can go to jail. Well, here's the legal mechanism that we're going to obviously be under at that point. If our clients are in front of a judge, whether it's bankruptcy, whether it's a normal court, federal court, state court, whatever court it is, at that point, we're going to say that the trust is triggered, because before that point, the protector is very likely to have declared an event of duress, and the assets are now offshore, the trustee is offshore, and so now we're really just talking about a foreign trust. If a court says, Mr. Client, I want you to bring all those assets back, what the client is going to do is comply in every way, shape, or form. Going to sign a letter, going to sign an order, going to get into the judge's chambers, call the trustee, and scream and yell and tell the trustee, get these assets back. I don't care what I said before, get them back. And so you're going to comply. Whatever the court asks you to do that is in your power to do, you're going to comply. Now, whether the offshore trustee complies or not is a different question. And so very likely the offshore trustee is not going to comply, because under the terms of the trust, they're going to deem your actions under duress, and actions made under duress are not going to be followed. So the net effect is that you're not going to do anything that puts you in direct contempt with the court, and at the same time, you know, you're also not going to have the assets transferred back. Does a judge have the power to still throw somebody in jail? Of course they do. They can do it. Do we have that case history? We have a few cases where clients have been put into jail. They're all cases where we would all on the phone on this webinar agree that those clients probably deserve to be in jail. They were really bad examples, and even in those cases, the vast majority of them were in jail for very short periods of time. And once it was proven that they could not get the assets back, in other words, after 2 weeks of sitting in jail, the client's attorney is going back into the judge saying, "Hey, he can't get the assets back," and so they are released. I've never had a client in jail for contempt. I can't imagine I ever will. The cases where that's happened are all very egregious with really bad guy clients. So it's more of a question of someone being just fearful over the concept. I hear it all the time as something that attorneys say, "Oh, that's why you don't want to do this." I think that's a really bad reason to not put yourself in a position where your assets are protected. Possession is 9/10 the law in this context. My philosophy is put your clients in a position where they have the upper hand. They can always make a deal. And if the deal is voluntarily and truly done, not under duress, then it's going to get done. So it's a great question, Don, and but the answer is never seen it anywhere near me or my clients, and it's not something that I worry about or lose sleep over. And once I explain this to clients, they don't either. So great question. Okay, let's go to the next question. The cost. Okay, you mentioned the cost is $23,000 for the bridge trust. That's a lot more than my normal estate planning fees. How do I address this with clients? It's a great question. So the answer is I know that our fees are really good, and I know the service we give is fantastic. I am absolutely unashamed of the fees, and it's really more than $23,000. It really works out to more like $29,000 or $30,000, because the asset management limited partnership is $6,000, and then LLCs cost $1,000 a piece. So often we're talking about $30,000 or more for a full plan. What I found is that clients that have an issue with the fee either get over it very quickly because they understand the value of the protection, and we're typically talking about estates $2 to $5 million and up. In the context of that, spending $30,000 to protect a couple of $1 million of your life savings that took you 40 years to earn, it's not a big cost. So I have very little pushback on the fees. If anybody really has a problem with it, that they just don't do it. But that's okay. I find that the clients that don't have a problem with the fee are the best clients to work with, and most of them don't. Most of them don't have a problem, and less as I go on. I mean, 10 years ago, I think clients were more touchy about it. I also haven't raised my fees in many years, I think 7 years now. So my fees have only gotten more reasonable because they really haven't gone up. Okay, great question. Thank you for asking that. Okay, another fee question. In your practice, do you charge by the hour? And is follow-up included? How does that work? I do not charge by the hour. I don't have even a way to keep track of my hours. I charge fee-based planning. The fees are inclusive. I do not surprise clients with fees. No one likes that. I wouldn't do it to myself. I wouldn't do it to a client. I tell them up front. I literally get the bad news out first if there's bad news, if they don't like the fee. I'd rather them know it right away, get over it or not. And then I never really have issues with fees. There's an annual fee. Currently it's $2,100 a year. That covers all of the offshore components, the annual re-registration, and it also covers our annual fee. We do minutes for our clients. We interface with all their professional advisors and with them, and we do not charge them. I have zero pushback on that. Clients just go, yeah, that's reasonable. I think we've changed our society and our mentality around ongoing continuity fees. I think people expect that now. I had one software developer, a friend of mine in a coaching class that I'm in, say, I wouldn't buy a piece of software that didn't have an ongoing fee because I'm not going to get the support. So people understand that you're getting value for that fee. This is another thing. If you're in an estate planning practice right now and you're not charging some type of annual fee, you're really missing an opportunity to stay connected to your clients. Not only is that fee ultimately become significant over the years with enough clients, but you're missing, I mean, I can't tell you how many estate planning attorneys I talk to who have been practicing 20 years or more that don't have relationships with 90% of the clients that they've ever done a transaction for. I still have relationships with 90% of all the people that I've ever done a transaction with. And I can tell you the annual fee is a huge part of that, because if they're paying me, they kind of reassess every year, well, what is he doing for me? And usually they call, or at least every 2 or 3 years they'll call and they'll go, well, just remind me, why are we doing this? And it kind of forces a connection between us, which I consider a good thing. Another reason why I don't charge hourly, I love talking to my clients. I mean, every time I talk to a client, I know I've built and strengthened a relationship. I consider that a good thing, and I would really encourage that if you're still in the old model of transactional and there's no annual fee, get out of that. Change it, even just for your estate planning. Charge a $499 annual fee and do updates for free. Do something, come up with some value that you can provide your clients. But don't just be doing transactions. You're really missing the boat. These are great questions. Thank you, guys. Okay, great. This one is, can you touch on how you identify prospective clients for asset protection services? Yes. I mentioned $2 million earlier. That is the sweet spot. 2 to 5 is the sweet spot. It's even really 1 to 5 of net worth, protectable net worth. This would be net worth that is not otherwise protected. So if you're in Florida or Texas and you have a $2 million home, you wouldn't count that because that's already protected. Or if a client has a defined benefit plan with $2 million in it, that's already protected, so you wouldn't count that. But of protectable assets, their brokerage account, their unprotected real estate, whatever they have, once you get to over 1 and certainly over 2, that is an excellent client for asset protection. And here's why. If you've got $2 to $5 million and you're 50 to 70 years old, which is most of the range where I see most people calling, even 40 to 70 now, that's taken you a lot of years to earn. That is what you're counting on to retire. And you've been around long enough to understand that there are predators out there. Your sensitivity to losing your $2 or $3 or $4 million is much higher than my clients that have 50 and $100 million. I wouldn't have guessed this when I started, but I have those huge clients, and let me tell you, they're much more no pasa nada about it. I mean, they're just like, I got attorneys. I've been sued 20 times. It always works out, and I'm not afraid of losing it all over a single lawsuit. They still do asset protection because they know it's smart, and we sometimes do it differently for them. We'll do a nest egg approach. We'll take $10 million, we'll peel it off, we'll put it in an offshore trust and forget about it. But the people who are really motivated is the dentist, the franchise guy, the small employer, the contractor. I mean, people who have assets that they can retire on comfortably, but they worked hard for them. Those people are extremely motivated. Trust me. So that's what I would be looking for in my client base. And I can tell you, you have a lot of those people. And ironically, some of those people don't need any estate planning. Now that the estate planning exemption is $5.5 million and going up per person, and maybe going away, who knows? Those same people don't need any estate planning or complicated estate planning. They just need a simple trust or will. But they do need asset protection. And so here's a way really that you can shift and pivot your practice to something that they really do need, that has a much higher price point, that it provides a much more comprehensive service to them that they really want. I would immediately be looking through my client base, identifying the top 3, and getting on the phone with me and saying, okay, Doug, I've got 3 that I've identified. How are we going to go about talking with them? And I will help you. I can tell you the answer is, and I think there's a question on this coming up, the answer is you just call them. Say, hey, John, I was looking at your file, I review it every year, and I really think we should have a conversation about protecting these assets. I mean, you're at the stage where we really don't want to lose them. And just watch what your client says. They're going to go, oh, God, I'm really glad you're calling about that. I've been thinking about it. Do not be hesitant, afraid, or nervous at all in just calling a client up and saying, I think we should be talking about asset protection. If they say, yeah, I thought about it, I went to a seminar, I'm not interested, well, great. But I can tell you 9 out of 10 are going to say the opposite. They're going to say, I've been thinking about this. I'm glad you called. I didn't know if you could do it or not. And your answer will be great. Well, I'm working with one of the nation's leading experts on it. We've co-counseled, and I'd really like to get you and he and I on the phone, and let's have a conversation, and we can just look at it. Schedule those calls, and we're off to the races. Great question. Thanks. Okay, so another question, what foreign venues do you do? Really good question. There's about 24 different offshore jurisdictions that have asset protection on the books. And the Cook Islands I use, obviously, I gave it as the example, is still the premier. They're the first, they're the most progressive as far as continuing to evolve the statute. They're the most progressive and have the most substantial infrastructure to support it. And here's my experience in working offshore. It is different. You're dealing with usually island nations, countries that don't have really developed infrastructures. They do work a little differently than us, and it's really important that you have a jurisdiction that is pretty serious about it. I've worked in many of these jurisdictions in some way or another. And I can tell you in my experience, the Cook Islands is the most professional. It's the one I would choose. I also work in Belize quite a bit. Belize has a unique advantage in that there's a way that we can work down there for a lower cost. And we do use Belize to register the bridge trust initially. But if we trigger it to the Cook Islands. So I use a dual jurisdiction structure with the bridge trust. We register in Belize to get our certificate and get our initial offshore component established, but then we trigger to the Cook Islands. And of course we have the option to trigger other places, but so far the Cooks has still been the best. Nevis is also a jurisdiction that I work in very often. We use a lot of Nevis LLCs, and we use those for when it's appropriate for a client to have an offshore LLC. Sometimes for holding their intellectual property portfolio, for example, or sometimes we'll use that in place of the Arizona Limited Partnership because the client is got an offshore reason, or they just don't want to have anyone else involved in the plan. They don't have a partner, and so we need to use an LLC. Nevis has a fantastic LLC statute, and again, on my website there's a really great article about Nevis and how it works and why it's so good. So those are the top 3 that I use the most. And, you know, the other ones are good as far as statutory. I think the execution of finding a provider is where it gets a little more dicey and more difficult. So, what I like to do is develop really strong relationships, because you will need favors. You will need them to do things for you. You will need to be able to call them and say, hey, my client really needs this put on the top of the pile. And so I personally have built very strong relationships in those 3 jurisdictions so that I can get that done for my clients when it counts. Because at the end of the day, my job is to protect the clients. That's my job. And I take it really seriously. I don't want to fail. I don't want to ever lose an asset for a client. And so I want to make sure that every step along the way, from the trustee offshore to the bankers offshore, I have really good relationships with and can get things done. But thank you for that question. That was a great question. Okay, so next question is, do I have to be an APC member to co-counsel, or can I just refer you clients? That's a great question. So the way the APC membership works is that there is no cost for it. And it is, once you join, you have access to all the intellectual property, all the resources, and of course to me and my staff. And the goal is that we co-counsel. So you bring in a client, and then we will co-counsel the case, and then we will share the fee. And you'll get privy to all of the inside information, the documents, how it works, the analysis. We'll do it all together. And my goal is to mentor and coach you into just being able to be more and more capable of doing asset protection cases. And so that's the goal. Some attorneys call me and say, I really don't want to co-counsel. I'd rather just refer this case to you. I don't need to be part of the fee. I just want to refer the case. Can I still do that? And of course the answer is yes. I'm happy to take referrals. And I understand there are some cases where we'd rather not be on that side of it. Sometimes you have a relationship with the client, or you're their corporate counsel, and you just don't feel comfortable being also their asset protection team. So, but any way you want to do it, we're very accommodating to that, and we'll so the answer is yes. You can absolutely just refer clients if you want. Okay, follow-up question on that one is, once my client moves forward on the asset protection, would they work directly with your office or through mine for documents, questions, etc.? The answer is that it's both, or how you want. So I have some attorneys, affiliate attorneys, who really want to have all client contact through their office. And so we deliver the documents, the parts of it that we do to their office. They deliver them to the client. They do all the communication with the client. And we're just kind of the back end for them. And we communicate mostly with the attorney, and either not at all or very little with the client on the front end. Others are quite the opposite. They want to refer it, they want to be involved, but they really don't want to, they're very happy for us to do all the direct interface with the client, gather the information we need, get the documents, go back and forth, and sometimes even directly send the documents to the client for signing, and then they'll participate in helping on the funding or the other parts of it that touch their existing planning. The answer is it's up to you, however you want to do it. And we have a software system that is built, that we've custom built. It's called the Vault. It is also on the Asset Protection Council website. In fact, I'll just pull it up here so you can see that. This is the Asset Protection Council website. Here's the resources tab. So you can see here's the case summaries and just a lot of information. A whole section on marketing your practice, by the way. Which, I mean, we talk about everything from, should you have a CRM? And the answer, of course, is yes, a customer resource management software. Which one? How does it work? I'm really sharing how I've built what I consider to be an amazing practice that is just really incredible, and the tools that I was able to find and use and develop over the past 20 years to do that. It's all here. What we also have is a vault, and this vault is something where you log in, and we will have a client record in there. It's secure. We can exchange the documents inside of the vault, information, etc. So this is all part of your membership to the Asset Protection Council. You get access to the vault, and that's how we determine how we work together with the client. And we have a checkbox right in the vault. Contact the affiliate attorney or contact the client for this record. So we've really dialed it in to be extremely efficient. There's a premise that the faster something is done, the higher the quality, and that I have found to be true. So when I talk to a client, they have the retainer agreement. If I've agreed to make a recommendation and engage them, they have a retainer agreement that day, in their inbox. I mean, and I talked to an attorney a while back. I needed some of my own legal work, and he said, okay, let me do a conflicts check and get you a retainer agreement. 2 weeks later, I'm pinging him going, where's my retainer agreement? Like, what's going on? Do you think I hired him? I absolutely did not, because if he can't get me a retainer agreement in any kind of timely fashion, how is he going to do with the work? So we have documents out to clients usually within 10 to 14 days. We just don't mess around. Clients don't want to mess around. You don't want to mess around. And believe me, they appreciate it. Believe me, they love it. You know, that's just the way we work, and you can expect that from us when you work with us. That's how we'll be. Okay, so is there a cost to be a member? I already answered that. No, there is not a cost to be a member. There's no cost. We see this as a win-win for us and you. We'll share the fee when we get a client. And the way that works is that in the initial 5 cases that we do together, the fee share is 25% of the legal fee goes to you. Once we've done 5 cases, then we step it up to 40%, because at that point we really see that you've gotten involved, you're doing it, you can really kind of take on more of the work, which often just means, you know, more of the client engagement. So we will still do the same back-end work that we've always done. Okay, as an APC member, can I use the intellectual property in my marketing activities? Yeah, yes, and the logo that you see, the coin, we have an incredible library of videos that you have access to, including the key concepts of asset protection. If you have not seen these, please go see them. I'll show you where those are. Here's my website. This video right here on the homepage, the Bridge Trust, it's 7.5 minutes. It's excellent. Right below it, there's something called the Key Concepts of Asset Protection. Click that, and you'll come to a 15-part series. These are all 3-minute videos. They are great. I send them to every prospect. When I send a retainer agreement, I also send a link to these. Watch them. You will love them, and you will see instantly why clients love them. And they're very effective to communicate how asset protection works. It goes through each of the concepts, you know, separate ownership from beneficial use and control, use a trust, you know, irrevocability, spendthrift provisions, self-settled trust. So it literally walks through all the key concepts that we use to accomplish the goal. So these things, and my really good affiliate attorneys are integrating these right into their website as well as into their follow-up marketing campaigns. The drip marketing campaign, when a lead comes in and then you're sending them emails, and they'll break them up into 15 emails, and they'll email them one by one to the lead. And again, all of this is stuff that we can help you with, that we've done for a long time. So okay, let me see if there's any more questions. No, I think that's it. If anyone has any last questions, please let me know. And otherwise, I would really encourage you to go to the APC membership website. Also, here's my upcoming events. If I'm near any of you, if you want to come and see me in person, May 23rd, I'll be in Spokane. May 31st, I'll be in Vegas for the Offshore Planning Institute. June 1st, we'll have another webinar. November 15th, I'll be at the National Association of the Estate Planning Council. I'm the keynote speaker in New Orleans. October 3rd through 6th, I'll be at Wealth Council. This year is in Hollywood, California. And on the 21st, Lehigh Estate Planning Council in Pennsylvania. So if any of those are near to you, I'd love to meet you in person, or if you happen to already be going to them, that's great. Otherwise, I will encourage you to call me, set up an appointment. You can email me directly, doug@lodmel.com, and ask me any questions you'd like. But more importantly, I would encourage you to, if we haven't spoken by phone yet, let's have a call. Let's just take 30 minutes and we can talk specifically about your practice, about the Asset Protection Council, about the details of the Bridge Trust if you'd like, anything you'd like to help you move along in your comfort level and get to the point where you're ready to get some clients on the phone and have that joint analysis meeting. That's the first step, is to do an analysis together, start with one client. And from there, figure out how you can make asset protection a core component of your practice, because this is the future. Clients need it, clients want it, and they're going to get it somewhere. I say they should get it from you. Thank you for joining me today. I really enjoyed this webinar. The questions were great. It makes it great when we have good questions, and you guys did a great job. I appreciate that. Thanks again. Remember, it's your money. Act like it. See you next time.